Executive Vice President and Chief Operating Officer here at Coastal Carolina University. I welcome you on behalf of our Board of Trustees, one of our members being here today, Natasha, Hanna, Board of Trustee member, and on behalf of our President, Dr. David Senzo. We're always pleased to partner with community groups, and we like to further the cause of education. We're especially pleased today to be able to partner with the League of Women Voters in this important initiative that they have been conducting statewide. This forum's speakers and panelists include very distinguished jurists and members of the bar, so I'm sure that we will all learn a good bit today. We thank you for your participation, and if there's anything we can ever do for you at Coastal Carolina University, please feel free to contact us, and I certainly hope that your time here today is both enjoyable and educational. We're going to begin with a Girl Scout color guard to post our flags. This is the Girl Scout Troop 368 from the Socastee area, and they will lead us in the Pledge of Allegiance to the flag, and we will follow that with a rendition of the Star Spangled Banner. Ladies.
Would everyone please rise? Color guard attention. Color guard advanced. Color guard, present your colors. Color guard, post your colors. Please join me in the Pledge of Allegiance to the United States of America. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We'll now hear the Star Spangled Banner from a double quartet of the Grand Strand Harmony Chorus, chapter of Sweet Anna Lines International.
So proudly we
Thank you so much. It's now my privilege and pleasure, and with no small amount of pride, to introduce to you a former star student in my constitutional law class, the chair of the League of Women Voters for Horry County, Miss Elizabeth Weems.
Welcome, everybody. I'm going to introduce Constance and Ernest to you. We're glad to see you here this evening. And before I introduce Constance, I just want to say that we're having a reception immediately following this forum, and you're all invited to come upstairs to the Wall Boardroom and join us up there. And thank you to the Girl Scouts. Thank you very much. And Grand Strand Harmony did a beautiful job. Constance and Ernest, our forum moderator tonight, graduated from the University of Virginia with a BA in Economics and graduated from the UNC School of Law with a Juris Doctor. She joined the Charleston School of Law faculty in 2007, teaching evidence and insurance law. In 2011, she was chosen Professor of the Year. Prior to coming to the Charleston School of Law, she served as a senior litigator in the Civil Litigation Division of the Charleston law firm Ernest & Cloy, LLC, where she managed the appellate practice for the firm. She was the lead counsel in the seminal case Gaskins versus Southern Farm Bureau, which was chosen as one of the 10 most important decisions of 2003 in South Carolina by Lawyers Weekly. But most important of all, she's a league member.
Thank you, Elizabeth, and thank you so much for being here. It's a pleasure for me to be here with you tonight and to talk about my favorite subject, independence and diversity in the judiciary. I speak a lot on this subject, and I have been involved with the League for a number of years. We have focused on this particular issue. I think we had our first forum in 2004, and we've had subsequent forums since then. Last August, the League was awarded a grant from the National League of Women Voters to focus on the idea of diversity and independence on the judiciary and to educate the citizenry of the state of South Carolina about the process of becoming a judge, what changes, if any, are needed to that process. And we have invited a very prestigious panel to speak to that issue tonight. So again, it's a pleasure to be here, and thank you all for being here. I'm going to introduce our keynote speakers, but I first wanted to just talk a little bit about the process of becoming a judge. If you're unfamiliar with the process, I'll give you the 5-minute sort of version of how you become a judge in South Carolina. What happens is when there is a vacancy in the judiciary, whether it is a circuit court vacancy, a family court vacancy, a Court of Appeals vacancy, or a Supreme Court vacancy, a notice goes out to all the members of the South Carolina Bar. And there are certain statutory requirements that are necessary to be met before a person can apply. They have to have practiced a certain number of years. They have to be a certain age, but they're fairly minimum. Once that open seat has been advertised, then any member of the bar can apply for that seat. You don't have to be a judge to be on the Court of Appeals, for example. You don't have to be a Court of Appeals judge to rise to the level of Supreme Court. Any member of the bar can apply for that position. And then what happens is they go through a qualifying process. And that's really where we're sort of focusing our initiative. Once the individual puts their name in the hat, so to speak, to become a judge, then they go through a process of qualifying. And in 1996, South Carolina changed the way that process occurred. By constitutional provision, there was concerns about legislative control and domination in the way that our judges were picked. Before 1996, what happened is generally you became a legislator, and then you got your friends in the legislature to appoint you to be a judge. And there was concern about that process. And so in 1996, by constitutional provision, there was a creation of what is called the Judicial Merit Selection Commission, the JMSC. The JMSC is made up of 10 members. Contemporaneous with the adoption of that constitutional provision, the South Carolina legislature passed a statute. And the statute said how the members of the commission were going to be chosen and by whom. So you might call it an end run around sort of the constitutional provision, because what happened is that contemporaneous with the creation of the commission, the statutory provision said that the Speaker of the House gets to appoint 5 members, 3 of whom have to be sitting legislators, and the President pro tem, who is currently Senator McConnell, gets to appoint 5 members, 3 of whom have to be sitting legislators. So out of the 10 members of the Judicial Merit Selection Commission, 6 of them are current legislators. 4 of them are citizens, private citizens. Of the 10 currently on the commission right now, there is 1 woman on the commission. Of the 4 individuals that are private citizens, Speaker Harrell appointed his brother as one of those private citizens. That raises questions about independence, I think, in the process, and that's something that we're going to talk about a little bit tonight. All right, so in addition to the JMSC, the constitutional provision created citizens committees. There are 5 citizens committees throughout the state of South Carolina. And we have a member of the Citizens Committee from the PD who's here tonight who's going to talk a little bit about what they do. The Citizens Committees are I think, usually 10 people also. They are appointed. And I think by experience or anecdotally, they are fairly diverse, which is a good thing. And they do a large amount of the investigation on the candidate before that candidate goes before the JMSC. Okay, so the Citizens Committee, and then there is a Bar Committee. Both of those committees then make a recommendation to JMSC. JMSC takes all that information, and then they investigate the candidate, they qualify the candidate. So if there is a seat open, there might be 5 people, 10 people, 20 people who put their names in to be elected to that seat or appointed to that seat by the legislature. The Judicial Merit Selection Commission is vested with the responsibility of qualifying 3 of those individuals and sending those 3 names on to the legislature. And then the legislature votes the seat to one of those 3 individuals. So that's your law lesson for tonight, okay? That's the process. Excuse me, when I talk, I get very dry. So that's a little bit about the process. Justice Hearn and I were at the Charleston School of Law graduation on Saturday, and our speaker was Lindsey Graham. And Senator Graham spoke about his work in Afghanistan and Iraq. And one of the things that he talked about that he's doing there is he's made several trips to Afghanistan and Iraq. And what he has been working on is setting up independent courts. And he talked about the fact that you must have a system in a democracy where a person can go before a court, a judge, and be judged on the rule of law, not judged on who they know or what they have. And he talked about how fundamental that is in creating democracies in Afghanistan and Iraq. And it made me think about this issue in the United States and how fundamental it is to our democracy that you can go into a court and be judged by the rule of law and not by who you know or what you have. So when we think about that in terms of an independent judiciary, it's so important. But why is diversity important? Why do we care about diversity? Well, part of being a judge, that independence is the perception that the judge is independent, because the perception is, in fact, the reality. And when litigants go before judges, they have to have confidence in that judge, in fact, is judging them on the rule of law and not something else. And when litigants go before a judiciary that is exclusively white male, that confidence is eroded. When you have a diverse judiciary, and there's statistical information in your packet from the Brennan Center, and they've done a lot of statistical analysis on what diversity on the bench means, it really is so fundamental as creating confidence in the judiciary, creating confidence in a system that is independent, that is transparent. And that's really at the heart of the matter tonight that we're going to talk about. So, all that being said, let me introduce our keynote speaker. Actually, we have 2. First, we're going to hear from Justice Kaye Hearn, and then we're going to hear from Lee Coggiola. Let me introduce Justice Hearn. Justice Hearn was elected to the South Carolina Supreme Court in May 2009. She is the 2nd female member of the court in its history. She was a family court judge beginning in 1986 and served as the first woman president of the Conference of Family Court Judges. In 1995, she was elected to the South Carolina Court of Appeals and was elected to be its first female chief in 1999. She is an FMU alumna, 79, who was the 2011 commencement speaker. She received her Bachelor of Arts, cum laude, from Bethany College in 1972, and her Juris Doctor, cum laude, from the University of South Carolina School of Law in 1977. But perhaps most importantly, she serves on the board at the Charleston School of Law. So it is a pleasure to have her here. Let me introduce Leslie Coggiola, and she will follow Justice Hearn. Lee Coggiola is the Disciplinary Counsel for the Supreme Court Commission on Lawyers and Judicial Conduct. She's a 1998 graduate of the USC School of Law with prior 11 years with IBM in systems and marketing. She has served as law clerk to Carol Connor in Richland County, served on the House of Delegates for the South Carolina Bar, and was chair of the Criminal Law Section. She was a commissioner at the Office of Indigent Defense. She is former president of the South Carolina Public Defender Association and an adjunct instructor at the USC School of Law. So without further ado, Justice Hearn.
Thank you. I assure you, when I put on my robe, I'm way taller than this. I want to thank the League of Women Voters for putting on this symposium and for the work they've done on this issue across the state. I think it's great to shed more light, let the light shine on this process. It seems fitting to begin this afternoon with the first line of the United States Constitution, which is, "We the people, in order to form a more perfect union." And what did those great patriot founders set forth in that magnificent document as the very first step, the initial goal in forming a perfect union? Does anyone know? Well, I'm going to tell you. It was to establish justice. The founders decreed the need to establish justice ahead of all the other stated goals of that perfect union, namely ensuring domestic tranquility, providing for the common defense, promoting the general welfare, and securing the blessings of liberty for posterity, to establish justice. The fact is that anywhere in the world, the cornerstone of democracy, the foundation of a justice system, is the rule of law, a concept that is totally dependent upon judicial independence. Equally important to upholding the rule of law is a diverse judiciary, a judiciary that reflects the faces of the people who come before it. The importance of upholding the rule of law and maintaining the respect which the people of this country have for our system of justice cannot be overstated. One only has to look at Afghanistan and other countries, as Constance and I heard Senator Graham discuss on Saturday. One only has to look at countries like that in the Middle East to see what happens when citizens have no confidence in the rule of law. I'm reminded of a great story I heard Chief Justice John Roberts tell at a judicial conference just a year ago that I think highlights the respect we have in this country for the rule of law. During a visit with the Chief Justice of a newly created nation in Africa, Chief Justice Roberts was asked, "What happens in your country when you rule against the government?" Chief Justice Roberts, assuming the African judge meant what repercussions occurred when the government lost a case before the court, said, "Absolutely nothing." "Ah, the same thing happens in our country." The justice from Africa responded. Chief Justice Roberts then very quickly realized that although both men used the same word, nothing, to describe what happened when the government was the losing party in a lawsuit, they meant two entirely different things. In the United States, because of the respect we have for the rule of law and the court system, there are no repercussions when a decision is rendered against the government. In the African nation, by contrast, nothing happens in the sense that the government simply ignores the ruling of the court and refuses to comply with it. We are incredibly fortunate to live in a country where important issues are decided every day in our court system. Issues such as the one decided in Bush v. Gore, who is entitled to serve as President of the United States. And whether we agree with that ultimate decision or not, we all respect it and we all accept it. And the reason that happens is because in the United States we have respect for the rule of law. I pray that we never lose that. I have been a state court judge for 25 years, and it has been an incredibly rewarding experience. Although we hear a lot about federal judges on TV and in the news media, the vast majority of judicial work in this country is done by state court judges. Most estimates are that 95% of the cases in the United States are resolved by state court judges. So who are the state court judges in South Carolina? Well, first we have the magistrates. There are approximately 300 magistrates in this state. Magistrates' courts are our small claims courts. They are appointed by the local state senator with the approval of the governor, and they have civil jurisdiction over cases involving up to $7,500 and criminal jurisdiction to impose fines of $500 and sentences of up to 30 days in jail. We also have 46 probate judges in South Carolina whose jurisdiction extends to matters involving estates of decedents or incompetents. Our probate judges are the only members of the South Carolina judiciary who are elected by the public. Neither magistrates nor probate judges are required to be attorneys, although an increasing minority are members of the bar. We also have many municipal judges who serve throughout South Carolina, such as my close friend Judge Jennifer Wilson, Chief Judge for Myrtle Beach, who's here with us today. Municipal judges are appointed by the various city councils or other governing entities. Magistrates, probate judges, and municipal judges all have the power to impanel juries in certain types of cases, and they really are the front lines of our judiciary, the judges that most citizens see when they go to court. Additionally, many of our counties, 22 out of 46 to be exact, also employ a judge that's known as a master in equity. Masters in equity hear non-jury matters such as mortgage foreclosures and complex real estate litigation, where a jury is not required. Here in Horry County, we have the only female master in equity in South Carolina. I swore her in, and I made a joke that from now on I was going to call her mistress in equity instead of master in equity. But her name is Cynthia Graham Howe. I do believe that we're about to have a second woman in the next few weeks elected from Dorchester County as a master in equity. The other members of our state judiciary are the family court judges, the circuit court judges, and the appellate judges. We have a separate family court system in this state, which has served as a model for many other states to emulate. There are 52 family court judges in South Carolina who have jurisdiction over divorce, custody, adoptions, DSS, abuse and neglect, and juvenile criminal matters. We also have 46 circuit judges who are the general jurisdiction trial judges in South Carolina. They try civil cases where the matter at stake is more than $7,500 and criminal matters all the way from shoplifting up into murder, death penalty cases. While family court judges do not use juries, the family court judges are both the finders of the fact and the makers of the law. They make conclusions of law as well as findings of fact. Circuit judges, although they may hear matters non-jury, do frequently impanel juries in both the civil and the criminal context. But in addition to these two types of trial judges, family and circuit, we also have two appellate courts in this state, the Court of Appeals and the Supreme Court. Now, the 9 members of the South Carolina Court of Appeals sit in panels of 3 to hear appeals from civil and criminal cases. I was privileged to be a member of the Court of Appeals for 15 years and served as its chief judge for 10 years. The Court of Appeals is what's known as an intermediate appellate court. The court of last resort in the state is the Supreme Court, which has 5 members. In addition to cases that we agree to hear from decisions issued by the Court of Appeals, lawyer disciplinary cases, which Coggiola is in charge of prosecuting, and we'll talk to you a little bit about today. But in addition to those kinds of cases, we also take cases in our original jurisdiction, such as the Myrtle Beach helmet law case, and we also are the rulemaking body for the courts of the state. I think the mottos of our 2 appellate courts kind of say it all about the philosophies, and they're very descriptive. The Court of Appeals motto is to each his due, while the Supreme Court motto is nil ultra, or none higher. Now, other than magistrates, probate judges, municipal judges, and masters in equity, The vast majority of our state court judges, as Constance told you, are elected. However, we are not elected by the general public. In South Carolina, judges are elected by the General Assembly. I once heard it said that most judges believe the system by which they got to be a judge is the best possible system. And I guess I'm no exception to that general rule, because I do believe our system